I just pressed the means we've got to wait for the stream to fire up all across the fruited plain of the internet. Before we go ahead and get started, got to make sure those tubes are warmed up and working. And it looks like here today they are. That's tremendous. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about the egregious Fani Willis. This is coming from a motion that Donald Trump filed in the Georgia RICO case that we are going to peer inside of because we have a hearing coming up very soon next week, which we are going to be covering the day after Valentine's Day, very apropos, for Fani Willis and the Nathan Wade motion to dismiss the case because of their affair hearing that's going to be in front of Judge McAfee. And so everybody's finishing filing their motions because we're going to have to debate about that very soon. And Trump submitted his reply today. And he didn't reply to the full filing that Fani submitted, which we already read through here. And remember, Fani said, we don't need a hearing at all. Really, that was her crux of her argument was, well, first of all, much ado about nothing. Okay, if we want to have a bang house, on Fulton County taxpayer dollars, well, that's their prerogative. That's our prerogative and their prerogative, and they can vote us out next time or whatever. But she said, moreover, there doesn't need to even be a hearing because Nathan Wade submitted this affidavit and that's good enough. And he swears under penalty of perjury, blah, blah, blah. Well, Trump says, no. Okay. First of all, that's not good enough. And they are saying that Fani should be disqualified because of her church speech, which we've listened to a few times here, which we're not going to do again so we can save our brain cells. But they did put it in her transcript in the motion. So we'll read through it and see the point that they make that she is the person who disqualified herself, right? Her statements have shown that she is very biased and not somebody who can be trusted with this case. So she's got to go. Trump submitted that. We also have Shafer, another co-defendant in the RICO case, is called David Shafer. He's been charged with crimes and he is also now joining in on the fun, right? Remember, Mike Roman submitted this. Then we had Donald Trump join in on this. We've got Shafer's joining in on this. And tomorrow, I think we're also going to hear from Jeffrey Clark. Jeffrey Clark is also joining in on this because he's been charged as well. So we'll see what is happening with all of those filings. Before we hear from some of these people who have reaction to this, George Conway, he is basically now in a cheerleader outfit with pom-poms, yeah, for the opinion that came out yesterday out of the DC Circuit Court. You're going to hear this, guy. It's like, man, you are laying it on thick, brother. What happened? Okay, so he's just going to, it's so beautiful that the Supreme Court doesn't even need to look at it. In fact, I slept with this under my pillow last night, and I've never slept so nicely. So we're going to hear from him. We're also going to hear from Crazy Eyes Griswold, who, remember that she is going to be counting the votes. She's the Secretary of State, okay? They are the scorekeeper. And she's going to come out and say that an entire political party needs to be dealt with, essentially, because they're making threats, right? So we're going to go through all that, hear from those whack jobs later on in the first segment. Then we're going to turn our attention to what's happening in Florida. There are a bunch of filings down there, all about redactions and about things being sealed and permission for leave to file that under seal and to file this redacted. And we want to see what the heck's going on with the case, right? If Jack Smith is accurate that there is a lot of evidence here, why can't we hear what some of the evidence is? Okay, minus the classified document stuff. But he wants everything filed under seal. FBI investigators' names, all of it. And we have a presumption of access because we are supposed to live in a transparent country. But a couple filings came out. First of all, Trump wanted permission to go file some additional stuff, and he needed permission of the court to do that, to file it unredacted, right? So that we can see what's inside of it. And so he submitted a motion. Jack Smith opposed this, says, no, it's sensitive and secret. You can't see anything. And then Trump replied to that. And now Judge Cannon came out and said, Trump actually wins this in part, right? We are going to default to letting us see some of this stuff. And so we're going to read through her ruling. She grants his request in part. Then in another filing, she grants Smith's request in part. to allow him to file something under seal. And so we've got under seal, we've got redactions inside, and then we've got ex parte filings, right? Which is when Jack Smith just sends an email or a filing to the judge and doesn't include the other side, right? Just talking without including the opposing party. So Jack Smith gets a ruling on that one. We have a scheduling order, so we're going to see what's coming up in the Florida case. And then we're going to hear from Representative Luna, who says, there's massive collusion here between all the different branches of government to go and stop Trump. Everybody who's working at, FBI and others, and saying that there needs to be some consequences from that. And so we'll hear from Representative Luna as well. And so you can see, my friends, it's a beautiful, beautiful Wednesday. I hope you're having an amazing week. Hopefully it's rocking and rolling right along as smooth as can possibly be. But we're glad that you're here. Now, this morning we had a great members only stream at watchingthewatchers.locals.com. We talked about Biden, we talked about the border, we talked about Tucker and what's going on over there with his interview with Putin and how everyone's melting down over that. And we talked a little bit about Rana, some of the election stuff. And so we have a great stream in the mornings. We'd love it if you joined us, members only, watchingthewatchers.locals.com. We do streams on Saturday and we do an after party. As soon as we're done here, we go to Locals and hang out and debriefed. If you want to access any of the PDFs that we're about to go through, you can find them all on our website, robertgovea.com. Link is down in the description below. You can access the PDFs. You can sign up for our daily newsletter. You can shop at the shop, get some good gear so you can look good while you're watching the show. And then lastly, our newest project, and I'm super excited about this. We had a ton of fun on this morning. If you missed it, it's still up there so you can go watch. But watcherlodge.com, which is our sovereignty and our self-development project, our community now, that we're really focused on building out. Today we had our Building Your Survival Squad event, and it was great. We went for about an hour and 20 minutes, and I'll share with you what we talked about over there. So if you want to catch this, but these were the slides that we went through. So all of our survival squad slides, we talked about FEMA, national emergencies. We talked about Ben Franklin, this great book here from Clay Martin, all the survival squad roles, all the survival squad resources, different action items for all the different roles, defense, food supply, high priority things to do, and so on. And then we built out or discussed how to build out our emergency master plan, which is this document. And the template's available. It's all, you can grab it all free for the next 48 hours. Then I'm putting it behind the paywall. But the emergency master plan, okay, your EMP, this is your survival plan. And we went through the template and I explained everything that is inside. This is exactly what I'm building. This is what our family is going to be creating in the event of an emergency. We want to know what to do, right? Local area instructions, if we have to evacuate, shelter in place instructions, and so on. And so watcherlodge.com, it has it all available. You can definitely go check that out and download it all for free for the next 48 hours, right? Then it is going behind a paywall. And so if you want to go over there, let me just show you what it looks like. Watcherlodge.com. We got a bunch of other events coming up at the lodge, so make sure you're RSVPing for those as well. Saturday, we're going to be doing our scanner unboxing. So our SDS 200 scanner unboxing. And then you see here, this is the actual, when you click that button, so the survival squad, it's showing me the back end of this, but the survival squad EMP community calendar, click this on the left. And then what you're going to see is the actual course. And the course is going to look like this, right? So this is the full event is here. The chat is there. And so go check that out, watcherlodge.com. You can see what we talked about this morning. And it was a real fun event. And it's going to be free, of course, until it goes into the lodge archives. Sign up for the Saturday stream and some other stuff there, watcherlodge.com. All right. And the forms. If you're looking for the forms, then it's right there, Survival Squad EMP. So when you click it and you go to the course, you're going to be in the course. And here, let me just show you right here. So this is where the form is, right there. That is the link right there. Click that, you'll get the template. That's the form for anybody who wants it. All right. So amazing. Now, that is, thanks for letting me share that with you, my friends. Watcherlodge.com. Links are in the description below. And it's a lot of fun. So go check that out. Get prepared. All right. Nobody's dying here. Not on our watch. All right. Let's get to it, my friends. We've got some meat and potatoes to dig into, and Fani is afoot. And apparently there's a new filing that just dropped, huh? From Fani. Huh. Very curious. Very curious. All right. So let's get right to it. Trump slams Fani Willis, calling her actions egregious, in particular, her speech to the church, where she came out and called everybody on the other side a bunch of racists. And that was inappropriate for a prosecutor who's supposed to be fair, neutral, unbiased, nonpartisan, speak through their filings, not use the power of their office to go out there and slam defendants who don't have the same power. But she did that because she's Fani Willis, the biggest Fani in Georgia. Nobody can compete with her, clearly. So we're going to go through this because Trump replied to her, and this is about the motion to disqualify Fani and the motion to dismiss the case. And it's a big RICO case, 19 co-defendants, only, I think, 15 of them are remaining. But the idea is that they're all joining in on this. So the affair from Nathan and Fani has now been so uncovered that it warrants multiple co-defendants joining in. They all want their case dismissed because you can't hide it anymore. So Fani responded, and she does not want this hearing to happen. She does not want to debate any of this. Trump is saying the hearing has to stay on. Co-defendant Shafer also filed his motion joining the efforts, and we'll see what he said as well before we get reaction from Crazy Eyes and George Conway. But here is the filing. Donald Trump replies to Fani Willis's motion, and Fani is opposing Roman's motion and Cheely's motion and Trump's motion to dismiss this case and to disqualify DA Fani. And so Trump is only responding in kind of a narrow way. Remember, Fani's motion was big. She says, first of all, we didn't cohabitate, and we never commingled funds, and we used our personal funds when we went to Napa Valley and on the Caribbean. And so, if we want to indict each other in our bedrooms, we're allowed to do that. But it doesn't impact the case. In other words, it's not material. And Trump says, hold on a minute. You called us racists. You went out to your congregation in Fulton County and said that we're racists. And that is inappropriate for a prosecutor because now you're tainting the jury pool and you're showing extreme prejudice in the case. So here is what Trump is responding to, because Fani wrote the big motion. We read it here. You can catch that in prior videos. But here he's saying, look, all right, President Trump, Your Honor, Judge McAfee, he files this reply to Fani's response. And specifically, he is replying in opposition to just this one limited section that Fani put in there. 1C of the responses on pages 17 through 18 says, first of all, this is Trump writing, the state, Fani, first claims that Fani's extrajudicial public comments, this is her church speech, in her well-publicized MLK holiday weekend church speech, she said in her filing to you, Judge, quote, neither referenced this case. She said, my speech didn't reference this case, and it didn't reference the defendants. I was talking about something else. Trump's people say nothing could be further from the truth, obviously. Says the DA, Fani, she said in pertinent part the following. We have a whole block quote here, so let's just read it, shall we? Fani's up at the podium. She says, why does Fulton County Commissioner Thorne and so many others, who's she talking about? Who could that be? Who's the subject? She says it wasn't the case or the defendant, so who? Why do so many others question my decision in special counsel? She says, Lord, you're flawed, hard-headed, and imperfect child. I'm a little confused, is what she said. Remember? I appointed 3 special counsel. And they insert themselves. They say, yeah, in this very case, which the DA now claims she did not reference. That's Trump's lawyer. Oops. She says, I appointed 3 special counsel. For what? What'd you appoint him there for, Fani? Oh, yeah, the Trump RICO prosecution. So why did you then claim in your filing to the court, you can just make crap up in court filings as much as they like to. You can't. That's a lie. Or a fib, right? It's a for what? Did she hire 3 special counsel, a black guy, a white guy, and a white woman for some other case that we're not aware of? She says, as is my right to do. I pay them all the same hourly rate. But they, who's that? I wonder who that could be, Fani. They only attack one. I hired 1 white woman, says Fani, a good personal friend and a great lawyer. A superstar, I tell you. I hired 1 white man, brilliant, my friend, and a great lawyer. And I hired 1 black man, another superstar, a great friend and a great lawyer, and apparently a great lay. Worth $1 million to her. and the people of Georgia. Now, oh Lord, she says, oh Lord, they're going to be mad when I call them out on this nonsense. And remember, I'm pretty sure she didn't sleep with this white dude, which I'm still upset about. You know, it's very discriminatory. So, well, okay, we can leave that for another conversation. But white woman, I don't know if she slept with him or this white man. That's the distinguishing feature. It's not the fact that they're black, which is racist for her to say, but that's how they interpret all this, because they treat people like trading cards. It's disgusting. Says first thing that they say, this is Fani, oh, she going to play the race card now. But no, God, isn't it them who's playing the race card when they only question one? Isn't it them playing the race card when they constantly think I need someone from some other jurisdiction in some other state to tell me how to do a job I've been doing for almost 30 years? God, why don't they look at themselves and just be honest? I mean, can't they? You can see all these are bolded out. They're like, who's she talking about? Who is this? Can't they keep it 100 with themselves, right? Come on. Why are they so surprised that a diverse team that I assembled, your child can accomplish extraordinary things? Yes, God, wasn't it them that attacked this lawyer of impeccable credentials? Her man now. The black man I chose has been a judge, this is Nathan, here we go, for more than 10 years, huh? Run a private practice, more than 20 represented businesses and civil litigation. I ain't done. Y'all, he served as a prosecutor, a criminal defense lawyer, a special assistant attorney general, one chief justice, Robert Bayham Award from the State Bar of Georgia. You know, they, again, who is this? They ain't just giving this to black men. How come, God, the same black man I hired was acceptable when a Republican in another county hired him and paid him twice the rate? Oh, y'all ain't hear me, all right? In another county, the elected official has the authority to pay him twice the rate. Why is the white male Republican's judgment good enough, but the black female Democrats not yet? So I don't know who she's talking about. If she's not talking about Trump or Trump's people, because they're the ones, okay, they filed this claim, Trump and these other co-defendants, including Mike Roman, saying that they are biased, and she's responding to them. That's who they is, the defendants. So they said, okay, we got that transcript from Atlanta News First, saying, now, a couple things here. In support of this motion, they say Trump also adopts the arguments made in Shafer's filing, which we're going to look at next, titled Motion to Disqualify DA Willis and her office from further prosecution. We're also adopting that. And also in Clark's filing, the motion to adopt as well. And tomorrow I'm anticipating we get to Clark's filing as well. But here is, they say, we're adopting those. Now, of course, at the end of this comment, they note Fani Willis diffidently, she neglected to mention, yeah, this is a great point, neglected. Huh, that's weird. Why did she's in the house of God. She's supposed to be honest about her past transgressions and her sins. But she neglected in front of his holiness. So neglected to mention that she only had an intimate personal relationship with the person she referred to as the black man, the only one, which is very racist, and not the white women or the white man, who's Anna Cross and John Floyd, when she wrongfully accused them of playing the race card. She didn't sleep with the others, as far as we know. So they tell us. Now, the speech from Fani, she says she wasn't talking about us, but clearly she was. She referred to they and us all the time. Why are they coming at me? What do you mean they? They filed a motion to dismiss the case and disqualify the case. It's the only people who are coming at you. They're the ones raising the claim. Okay, so it's clearly them. But not only that, the speech was also made 6 days after they filed their motion. So the motion to dismiss comes in. Fani throws a hissy fit. She goes out in church, even though she was, technically the adulterer because he was still married. The speech was 2 days after the motion was brought up. She goes out, starts ranting and raving. So the speech was 2 days after the motion was brought up in open court on January 12th, and the court announced that an evidentiary hearing would be scheduled in February. The speech was also during MLK holiday weekend, where it's going to get maximum exposure. Now, Commissioner Thorne in minor part, but first and foremost, defendants through defense counsel, specifically Roman and others, this had led to the exposure of and the outcry about, right? They filed these motions. And there was a lot of outcry about an inappropriate relationship between Wade and Willis, in particular about the DA's improper hiring of Wade. Thus, who else would be the DA? Would the DA be repeatedly and predominantly referring to in her use of the words they and them? Right now, they're like, this is kind of dry because they're like, clearly she's talking about them. Like, who else is she talking about? We filed the motions. She's responding to her being exposed by the motions. That's who we are. Who else could it be other than us? Now, those references are just as clear as the fact that her unnamed reference to the hired, quote, black man could only be Wade. There's no one else. From the day of the speech forward, not a single reporter, not a journalist, not a single media outlet has expressed the slightest bit of doubt that the DA's Fani's, that her racially invective comments were in direct response to Mike Roman's allegations in his court filing and were directed, she was responding to defendants, the defense counsel as well, saying, as this court is aware, even before the speech, Fani, in private emails to defense counsel on January 10th, had already gratuitously and falsely accused the defense counsel of racism, okay? So Fani is already crying racism. It's just, it's like, aren't you tired of that? Like, is everything racist to you, okay? These are defense attorneys. You're the one banging your special prosecutor. Relax. So as the court is aware, right, she's already calling us racists for everything. I don't know what they did. Probably nothing. I'm sure it's nothing, right? Because it's Fani calling them racist. So clearly just throw that one right in the garbage. Oh, Fani said it? Okay, so forget it. Now, as one prominent commentator, this guy called Eli Honig, said, he's a former, and he's not a like MAGA Trumper at all. He's a former federal and state prosecutor. He insightfully noted in an article in New Magazine's Intelligencer. He published this. He says, after these allegations surfaced, Willis somehow made it even worse. And we were watching this train wreck in real time. We're like, what is she doing? Prosecutors love to claim that we, quote, do our talking in court. They say that all the time. Oh, we'll let our filings do the speaking. And then Merrick Garland leaks everything to the Washington Post. Okay. Now, preferably accompanied, so he writes this, preferably accompanied by a dramatic lowering of the sunglasses. We prefer to do our filings in the courtroom because prosecutors are so cool and hip. Give me a break. This is more than a catchphrase, he says. Okay, we don't just say it. It's an affirmation of the core duty to protect the defendant's liberty, which is true, right? The reason prosecutors they have all the power in the first place. They have the charging power. They have the discovery power, right? They have all of the evidence in their refrigerators. You don't. They have all the money in the world. They have everything. Then they also have the power of the public speech, of the public, bully pulpit. So it's critical to the defendant's liberty. And his article goes on. It's critical to the integrity of our criminal process. Indeed, under the Georgia rules of professional conduct, he digs in, and pretty much every other professional code ever, prosecutors must, quote, refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. Not supposed to do that. And it's in the rules. It's not like some blog post. But Willis did just that, says Eli. Days after Trump's co-defendant, Mike Roman, filed a motion relating to Wade, Willis responded not in a court filing, but she went in a speech. She went from the pulpit of the historic black church on MLK Day. The cameras were rolling. Willis told the assembled congregation and the general public, it was being live streamed all over the place, that the defendants had raised allegations about Wade, talking about her court case. Criminal defendants are entitled to make motions, by the way. He says, okay, like we're allowed to file We're allowed to contest you, Fani. The fact that we say that you're dishonest and a liar, all these things, that's related to the defense of the case, okay? It's not because of your race. He says criminal defendants are entitled to make motions, by the way. Like, we don't have to just sit there and just, okay, a black prosecutor indicted us. I guess that's the case. Case closed. Guilty, Your Honor. Fani's prosecuting me. But she says they raised allegations about this because of Wade's race, which is insane. Now, these public comments by DA attorney are anathema to the prosecutorial ethics and to fair practice. Willis, who is enormously popular in Fulton County, for some reason, she received over 71% of the Democratic primary vote, because you know how Democrats are, then ran unopposed in the general election. She publicly calls the defense teams in her highest profile case racists. Publicly, in front of everybody. What could outrage a potential jury pool more than that? Is there anything? Various judges have slapped pretrial gag orders on Trump and his other cases to prevent him from making inflammatory public statements outside of court that could prejudice the jury pool. But now Willis has done exactly that. And all the same people who cry about Trump every day on MS, silent, nothing. And Trump just actually calls out, the same type of stuff. He says, why is Judge Areola Engeron playing footsie with his court clerk, the principal law clerk, on the same level, who's ruling on every motion with him? Calling that out, they say, you're gagged. You can't talk about that. And then Engeron moved the cameras around because they're sick. Right? That's actually what the First Amendment is about. Trump is a defendant. Trump is not a prosecutor. The defense has the right to free speech because that's the only power we have. Hello. We don't have the power of evidence because the evidence is in your refrigerator, government. We don't have the power of the money because you have it all, because you just print it and shove it in your budgets. We have nothing. The only thing we have is free speech and the law, what's left of it. So it is to protect the defense, not the other side. So the gag orders against Trump are ridiculous, and Willis can run free. And same with the DOJ, by the way. Okay, they just don't file it because they're not morons, or they don't, talk about it in public in their church proceedings, live stream to America, because they think they're untouchable. I mean, the colossal arrogance of what is happening in this county is wild, but absolutely inappropriate. Double standards twice, right? Double standards both ways. So they say undersigned lead counsel can only hope that at the scheduled evidentiary hearing, which is scheduled for next week, which we cannot wait to cover, the DA will be required to explain in testimony under oath who else she was referring to as, quote, playing the race card. Okay, who else was this, Fani? If it wasn't Trump and our defense team and Roman's lawyers and everyone, who was it? If it wasn't the defense and the defense counsel. Saying, as this continues, now stated succinctly, Fani's position in its filed response is preposterous, and it's disingenuous at best, and it's an outright lie at worst. It is an after-the-fact futile attempt to mislead this court. She knew what she said, and she's trying to paper over it after the fact, and Judge, that is dishonest. Now, the state claims that Trump's motion to adopt and supplement raises vague and plaintive cries of due process. Nonsense. President Trump does not even mention due process in his motion. Idiots. This is just another instance of misrepresentation designed to delude this court. And we made this point when we were reading through Fani's motion. Like, they were talking about stuff nobody was even talking about. It's like, are you just trying to like fill in the pages? Like, you're just trying to meet a page limit? Like, I remember that from high school and college. Like, I know what you're doing. All right. I was in law school too. We did that too there, Okay. Go copy and paste some more case law. So what were you talking about? She had due process. Well, he didn't even talk about it, weirdo. So for some unknown reason, yeah, see, same thing. The state's response talks about selective prosecution, voir dire, and change of venue. Now, like, the state must be confused. The threshold issues are disqualification of the DA and the dismissal of the case. That's what we're talking about. Remember, there was that one sentence in that weird motion I thought was written by an intern, but maybe that's an insult to interns. Maybe Fani wrote it. They were saying that the defense has no legal authority to pick their own prosecutors. And they cited case law for that. We said, what? Nobody's trying to pick their prosecutors. It's about disqualification of this prosecutor. So you're reframing the argument and then making arguments about an argument no one's making. They're just saying Fani's got to go because she's corrupt. Whatever you do after that's not our point. But they were arguing around the point. So they say, let's correct this, people. Maybe what Fani expects this court to do is to acquiesce in and accept at face value her proclamation that she is unlike all other prosecutors. And this is what we've been saying from day one. The biggest Fani in Georgia, right? And that nobody, they're not like she's not like other prosecutors. She's the biggest Fani. That this DA is somehow something special. That this DA must be treated differently, almost as though she's above the law. Now, that the ethical rules and laws simply don't apply to her. She can do whatever she wants. That this Fani alone can make prejudicial, out-of-court, racially partisan, and invidious statements about this case, and about defense counsel, and about the defendants like Donald Trump, whenever she pleases, in clear violation of her ethical duties as a prosecutor, and therefore that this court is now powerless to punish her by dismissal of the case and her disqualification, and instead may only seek to undo the substantial prejudice that she creates during jury selection? Such hubris, such self-consequence. She can go wreck everything and she'll fix it later. Because if we dismiss the case, that's too offensive to the great Fani. The state knows better. The state knows that improper extrajudicial public comments by a prosecutor in the state of Georgia may be dealt with by disqualification. There's 1988 case law that supports it. The Supreme Court was asked to overturn a conviction because allegedly unethical extrajudicial statements by the prosecutor should have required his disqualifications. A prosecutor was running his mouth. Now, after discussing the ethical prohibitions against making extrajudicial statements, the court found that the prosecutor's public comment did not require disqualification. But in so holding, the court affirmatively signaled that if the improper out-of-court remarks by a prosecutor were, quote, egregious, right, that's the standard, then disqualification would be a remedy. So they're saying, yep, this is egregious. Here, Fani's conduct was indeed egregious. It was undeniably unethical. Her MLK holiday, quote, church speech intentionally and in bad faith injected race and religion and politics into the case, and it stoked racial animus by, among other statements, asking God why defense counsel and why defendants were questioning her conduct in hiring a black man, but not his white counterparts, and why the judgment of a female, black female, why, God, of a black female Democrat wasn't as good as a white male Republican. And she did so publicly, and did it to denounce and to rebuke defense counsel and the defendants for having the audacity to challenge her personal and her professional conduct, and to defend her public and political reputation against the allegations that Mike Roman made about her and Wade's indictments of each other. Now, the DA's provocative, Fani, and her inflammatory extrajudicial racial comments made in a widely publicized speech at a historical black church in Atlanta and cloaked in repeated references to why, God? It catalyzes the quintessential, the explicit appearance of impropriety regarding her prosecutorial judgment and her conduct. Now, as everyone involved in this case well knows, Judge McAfee, Trump's team writes, this is not the first time in this matter that Fani's incredibly poor judgment created an appearance of impropriety resulting in her disqualification. Now, Judge McBurney also took her to task during the special grand jury's investigation of the now Lieutenant Governor Burt Jones. Remember this? Fani held a fundraiser for his opponent for that position. Fani went out and campaigned against someone. Judge McBurney noted, says, the optics are horrific, and called it a what were you thinking moment. She thought, well, it's a blue county. I got elected by 71% of the vote. Who cares? Now, the present case is not a what you were thinking moment. It's far worse. Fani utterly failed to learn any lesson about unethical behavior from that prior incident. Instead, Willis made a calculated and a purposeful choice here to disregard her special ethical responsibilities as a prosecutor because she conceived it was in her own best interest to do so. Now, she must not be given a third opportunity, Your Honor, to flagrantly flout the rules to serve her own self-interest to the prejudice of her defendants. And her egregious misconduct demands the dismissal of the indictment, and it demands her disqualification and all of the other relief that we requested in this motion. Signed by Trump attorney Stephen Sadow in Georgia, served on the opposite parties as well. Very good motion, and I think it's obvious. You can see in the transcript itself, she was clearly talking about them, and it was a huge mistake for her to do that, but they're, I don't think, good lawyers. I don't think they really know what the law is or how it works all that well, which is why they've gotten 0 convictions out of this case so far, 4 diversion agreements, and they are on their heels on this thing. They've got a hearing coming up. They've got a bunch of subpoenas to Fulton County's office, which we're learning that is apparently being challenged now, but other co-defendants are joining in on the fun. This is David Shafer. He also is now moving to join, and Trump is joining his motion, and we'll see if the others do as well. But this is what this looks like. Defendant David Shafer submits this motion to disqualify Fani Willis and also the entire Fulton County office from prosecution in this case. And they also want an evidentiary hearing. So this is going to be the big issue now in the immediate future. In addition to just disqualification and dismissal, we have questions about whether the hearing is going to take place and whether certain people from Fulton County are going to be subpoenaed and actually show up, including Big Fani Willis and Nathan Wade. So here is the quote they start off with. It's a quote from Fani Willis. Very curious quote. Apparently, Fani said this to a reporter at the Washington Post back on November 14, 2023. This is curious. Fani says, quote, "If I were to comment on any open case, it would be a reason to conflict my office out." That's weird. Is that the same woman who gave a 30-minute speech at church talking about her case? Does she care? What was happening there? Because that sounds like she knows you can't comment on an open case, you know? So why'd she do it for 30 minutes? Weird. Probably racism. Okay, I got her confused. But here, the Fulton County District Attorney, they say, by way of Mr. Shafer, she engaged in a pattern, they argue, of prosecutorial and forensic misconduct, which compels Fani from being disqualified, and not just her, but everybody, the entire office and their entire staff. Now, all the causes for this disqualification, they say, are self-inflicted blows, straying wildly from the legal guardrails, which are designed to protect the accused against wacky prosecutors. She, for over a year and a half, has given multiple interviews where she has improperly labeled the defendants fake electors. She's commented on the righteousness of her investigation, and she's shown a pattern of prejudicial public statements, including when she went to church. Let us set the stage here. First of all, in January, Mike Roman filed a motion to dismiss. He says that Fani began a romantic relationship with Nathan prior to hiring Mr. Wade. Okay, so Fani and Willis were apparently indicting each other in their judicial robes at a judicial conference back in 2019. Now, there's questions about this. Fani says, no, we weren't indicting each other before I hired him to indict Trump. Different type of indictment. But it's a question. Did she hire her lover, or did they form their loving relationship after he was hired? She says it was after, which maybe you excuse a little bit more. You're like, okay, they started working together and you know, the hearts just, you can't fight love, my friends. Or did she want to give her lover a nice, cushy job so that he could divorce his wife and go on cruises with her? So scandalous. Anyways, under a limited contract with a cap on the amount, and he billed like $600,000, estimates up through, you know, last year in the recent filings, $1 million. So they signed the contract on November 1st. The next day, Nathan Wade filed for divorce. Boom. One day after. See ya, honey. Nice 20 years with you. Have fun with the kids. In March 2022, Willis and Wade modified the initial services agreement. During that time, they continued their romantic relationship. They signed an extension of services that went through May 15, 2023. They continued their romantic relationship during these extensions, just kept signing the contract. You know, hey, baby, we got to go on a cruise. Can you re-up my contract? She's like, sure, honey, I love that. Where are we going? Napa Valley? Yeah, I love it. So they say that while the filings in the divorce case were sealed, they went all over the place. Napa Valley, California, Florida, Caribbean. Wade purchased tickets for them on Norwegian and Royal Caribbean cruise lines. Golly. So rather than properly addressing the allegations, Fani, right, didn't respond through her filing. She went into church and she made offensive, incendiary allegations. She was playing the race card, which is the lethal third rail of American politics. Now, Shafer, and Trump is joining this, says the obvious intent of her remarks are to inject and to infect the jury pool in Fulton with unfounded accusations of racism, and saying as an attorney and as a prosecutor, her comments directly affected this pending litigation before us. And that constitutes high misconduct, forensic misconduct that warrants her removal from office. Now, also, if true, if what Roman submitted in his original filings making these allegations, if he establishes that there was a conflict of interest in hiring her romantic partner, causing him to be paid hundreds of thousands of dollars and then getting benefits on cruises and exotic destinations, but never telling the Fulton County Board of Commissioners about the nature of the relationship, that's a problem. In fact, rather than reveal and disclose her relationship with Wade, she chose to conceal affirmatively the existence of those personal benefits. And she failed to disclose the benefits and the gifts on her that was omitted from her financial disclosure reports. And we've got copies of those that we'll look at. Now, financial disclosure reports are required for a reason. It forces the public official to list any benefits that the office received from any prohibited sources, like Nathan Wade, who are doing business with the county, right? If you get a benefit from somebody, you got to declare that. She instead chose to conceal the benefits. And let's take a quick look at that. This is a monster document, so we're going to scroll all the way down and see what these look like. Here is one of her financial disclosures from Fani Willis. Here you go, 2021, one of the recent, 2021 here. Here, this applies to everybody. Do you have any income, Fani? Any income? Yes, Ross Law Firm, State Accounting Office, Fulton County, I got that. Consulting company, it's myself. She's not married. Fani doesn't have a spouse, so nothing there. She stole someone else's spouse, and so nothing's disclosed. How come? A dividend income of $1,000 or more. Nothing there. Hey, a gift. How about this? A single source in the aggregate of $100 or more. What is a prohibited source? It means any person, business, or entity that the involved officer or employee knows or should know is seeking official action from the county, is seeking to do business, or is doing business with the county. Bingo! Fani Wade is doing business with the county. If this person represents a person who is seeking official action or has interest that may be affected by the performance or non-performance of official duties. That's another one too, right? Is a registered lobbyist. So if any of these people are giving you anything special, you got to write it down. Got to write it down. Put it in there, Fani. Didn't do it. Has interest that may be affected by the performance or non-performance of official duties. Well, Nathan Wade's might, and Fani Willis's might, and they're transacting indictments, and they're also transacting, cruise ships, vacations. So she didn't declare it at all. And when she scrolls all the way down and look at this, she signed this on April 15, 2022. Fani Willis signed it right there. Big Fani of Georgia. Curious. No disclosures at all. And why is that? Because we know she got a lot of money from Wade. So as we go back to the argument, they say, additionally, pursuant to the Constitution of Georgia, Willis is a public officer. She is a trustee of the people, and at all times, she's amenable to the people. Now, her conduct in hiring Wade caused hundreds of thousands of dollars to be paid to him, benefiting him personally, and failing to disclose her conduct is a clear breach of her fiduciary duty as a trustee to Fulton County. Now, pursuant to these facts and others, we now move for disqualification. We want her entire office gone. Her publicized statements have been severely prejudicial to the defense. And furthermore, Willis's employment of Wade to investigate and prosecute Trump and our clients, and payments to Wade of over $500,000, all while allowing Wade to pay for vacations for Fani and allowing him to pay other personal expenses for her, constitutes a disqualifying conflict of interest. And it's also a violation of ethical rules applicable under the law. Saying our clients, the defendants, Trump and others, here Shafer, says we possess a due process right to a fair trial. We do not want to have an impartial jury who thinks we're racist. We deserve to have a disinterested prosecutor who's interested in doing justice, not interested in funneling cruise money to her lover. The court furthermore possesses duties to ensure that we do get that fair trial, that we do get an impartial jury, and that public confidence is preserved in the impartiality of the administration of justice. But here, Fani's improper prejudicial actions, which are intentional, she did this, these are self-inflicted wounds, it warrants her disqualification, and it must be done to vindicate our rights and to restore the appearance of impartiality, which I completely agree with. Now, they give us some background. They say that Fani played the race card. She made statements to the news media trying to inject race into it. And they also recap her Georgia church speech, which we'll fast forward through because we read that previously. And they give the full comment, right? The full thing, much more than we read. Now, as she knew that they would be after that big, long speech, her statements were spread all over the place. And irrespective of her vagueness as to whom her statements were directed to, it's plain they were talking about Roman. Now, there were a flood of media stories that hit. They all came out. The media correctly understood that Willis was accusing her defendants of racism. They all reported accordingly. But then we have some other quotes. She made other statements. She called us fake electors, right? She called us fake electors. She said the fake electors. She was already commenting on this case. And all of these are headlines and stories. Now then, apparently there was also a book that she spoke to. Willis knew that this book that was featuring her as a hard-charging, afraid-of-nothing prosecutor would get extensive publication prior to the trial. She gave a bunch of interviews, and she gave conversations about racism. And she told the authors that since her office opened this RICO case, that they'd gotten a lot of comments. The comments were always racist. We have to live by certain standards. If you violate them, you catch a charge. So they say, look, all of this requires Fani to be disqualified. Lots of rules here. They're going through all the rules in Georgia, explaining what the rules say and why she's got to go. DA Willis publicized statements. It suggested that everyone else is motivated by race. She called everyone else racists. And the rules of professional conduct say you're not supposed to prejudice a jury panel like you're doing here. Talking about black man and white woman and so on. But they paid a lot of money. Willis failed to mention that they had a romantic relationship. And there is no evidence whatsoever that Willis did indict the white guy. No one knew that. Caused several hundreds of dollars, thousands of dollars to be paid to the white guy. Did the white guy ever get personal gifts? Did he go on airline flights? Did he get seat upgrades? Did he get hotel stays with Fani? Did the white guy get ocean cruises or wine country tours or beach vacations? No, he didn't. Thanks, Fani. And then they failed to report those gifts on her financial disclosure forms. Now, sadly, it is Willis who is playing the race card. And the Supreme Court has said that's not appropriate. But here, Willis has willfully and publicly raised racial arguments relating to the issues of this action, and that disqualifies her. Even the rules of professional conduct say you can't do this. The jury is supposed to be our protection of life and liberty against race or color prejudice. The jury's supposed to clear that out. But here, she's making it a primary thing. Her deliberate and inflammatory accusations at the Atlanta church that those objecting to her employment and compensation are racist, that is forensic misconduct, and it warrants her removal. Willis repeatedly emphasized and contrasted the special counsel Wade's, his race against the others. The DA's public appeals were literally based on bias and prejudice. Oh my God, she says, you forgot to mention that my life and the life of my family would be threatened so regularly. She improperly injected religion into this case, right? Talking about God all the time, saying that God had qualified her, that she's allegedly doing God's work. Totally inappropriate. So I guess if you don't vote in favor of conviction in Fani's courtroom, you're going against God. Her statement concerning her superstar team was vouching for the prosecution. She's talking up her case. Now, given their conviction rate, potential jurors would assume that defendants are guilty, given that prosecutors win 95% of its cases. Now, Willis also made inaccurate characterizations of Mr. Shafer, calling him fake electors, right? Prejudicing the media with that. They say, no, sorry. Mr. Shafer was acting pursuant to federal law and the Constitution. He was following the advice of his lawyers. He and other nominees were following the literal precedent. We've talked about this many times. The 1960 presidential election in the state of Hawaii, which was JFK versus Nixon, I believe. Shafer and the other, all right, and the other 2020 Republican presidential electors were not fake electors. And that type of commentary has greatly prejudiced Mr. Shafer, saying that all that was part of a calculated plan. She's making intentional and prejudicial public statements. And so the court needs to step in to protect the defendant's rights, saying there is a serious conflict of interest here. Willis and Wade, she paid him 3 times more than her annual salary, okay? She paid him money that she could not get, and then she got those gifts, and she was privately involved in a romantic relationship with him as well. That is an actual, substantial conflict of interest. They say now her hypocrisy in having a romantic relationship with Wade while criticizing Paul Howard for having his relationships is astonishing, right? And she did that. She got elected on that. I'm not going to sleep with my employees, and I'm not going to steal any money. Oops. Wrong on both accounts. Now, Willis is causing over $500,000 in county funds to be paid to her boyfriend. Oh, I love they use that word. I hope you enjoy your boyfriend and her receipt of gifts from Mr. Wade in the form of expensive trips. That is not in the interest of the state. Okay, Georgia doesn't care about these two lovebirds. Maybe they do. Willis, furthermore, presumably possesses a personal interest in her romantic interest, obviously, and Wade is continuing to get a large amount of money so they can go on vacation. Now, Willis knew what she was doing was wrong. She herself made accusations against the prior guy for, him indicting his employees, saying we have a right to disinterested, conflict-free prosecutors, not Fani and Wade. Now, their financial conflict is also a big problem. She's supposed to impartially discharge her duties, but her conduct in employing her boyfriend, there it is again, at a cost of over $500,000 while not disclosing any of this stuff is inappropriate. Other county attorneys have been indicted for stuff like this. This guy got thousands of dollars from a defendant in exchange for not prosecuting. All right, that's a little different. But here, the defense has also gotten Fulton County disclosure reports that we read through. Fani didn't disclose anything. Willis did not disclose any of the gifts that she got in her disclosure report. And we have other cases where that's a pretty big problem. Other people had relationships with lobbyists and stuff, and they did not disclose it. Now, her failure to list these gifts may reasonably be found to constitute evidence of intent. On the part of Fani. Intent to conceal the gifts. We got a mens rea right there. What is your mindset and we have an actus reus. We have an action. That's a crime. Mental state, a mindset plus an action. They're talking about criminal charges here. The prosecution's opposition doesn't address this at all, fails to address this. So they didn't say maybe they could charge her with a crime, but that's what they're saying, right? Maybe she did commit a crime. I don't know. We'll have to see. Willis and her actions are already under investigation by the Judiciary Committee and Georgia. And in light of her conduct, we're concerned about this, the potential consequences. What happens if there's a Republican administration in charge of the DOJ? Maybe she gets prosecuted. Now, her conduct constituted a clear breach of trust. Georgia says you can't do that. You have a fiduciary duty. Fani breached those duties. Hundreds of thousands of dollars got shifted over to her boyfriend. And she also didn't get proper authorization from Fulton County to employ him in the first place. Georgia law says you have to do certain things, and he didn't. And also, the code of ethics are critical to the proper functioning of our government. Willis violated these provisions. Undisclosed romantic relationship, hundreds of thousands of dollars. She got trips and vacations, and she violated her fiduciary duties. Now, all of this is earned. She earned it. She earned the disqualification of both herself and Wade. Her personal conflicts, her financial conflicts, her dereliction of the law, her duties of trust, her ethical rules, all breached. And a consequence, she made prejudicial statements in the aftermath. She did all the bad things, and then she talked about it and blamed everyone else for it. There's a quote that says, "The administration of the law, and especially that of the criminal law, should, like Caesar's wife, be above suspicion and should be free from all temptation, bias, or prejudice, so far as it is possible for our courts to accomplish." And Fani has wrecked all of that. And so the disqualification of Fani means the entire office has to go. Fani's the head dog. She's the biggest Fani in Georgia. So if she's gone, the rest got to go. Saying here, we need an evidentiary hearing. And this is the main point. Fani does not want this to happen at all. Saying an evidentiary hearing is necessary on our disqualification motions. We have facts in dispute. We need to get to the bottom of this. Nathan said they started a relationship after they met at the judicial conference. Witnesses say no. Witnesses say they got a little judicially on each other. You know what I mean? And the prosecution's opposition to the motion to dismiss attaches a declaration of Mr. Wade. He swears his personal relationship with Willis began after he got hired. But there's no declaration or affidavit from Willis, however. The filing was filed in her name as the DA. Now, of course, she cannot file such a filing if she knows it contains materially false statements. So, exactly right. Willis's office endorsed that affidavit. So she's saying that too. They don't know that we really met at the conference. They don't know any of that. Yeah, they do. Mr. Roman's reply filed on February 2nd represents that several witnesses will directly refute Mr. Wade's declaration. We saw you two at the bar, okay? We know what was going on there. You were not talking about judicial code of conduct, clearly. If the testimony of these witnesses proves credible, the inexorable conclusion would be that Mr. Wade has made false statements and lied in his declaration, which has been filed by Fani herself. They're going to get caught in a cover-up on her behalf of in the records in this case. This is why we need to have this hearing and why we really want the judge to continue, make it sure it stays, which would constitute yet another instance of forensic misconduct. Now, additionally, Mr. Wade declares that the expenses for personal travel were roughly divided between Wade and Willis. Now, presently, the public filings in the Wade divorce proceeding and the, quote, example of Willis purchasing tickets for herself and Mr. Wade are not roughly equal. All right. We don't think that they split things evenly. An evidentiary hearing is necessary to obtain the complete financial picture of the gifts and the benefits that Wade gave to Willis. Saying a full evidentiary hearing on the motions to disqualify Fani and Wade and the entire office is really needed to obtain true transparency. The rules say that motions shall be heard at a time and an evidentiary hearing would permit the defense to develop the evidence that relates to disqualification. So the court should allow a full evidentiary hearing to happen on February 15th, the day after Valentine's Day, which is just great. So when these two little lovebirds are on, whatever lakeside steakhouse they're at, indulging on the dollar dime of Fulton County, they got court the next day. Now, counsel understands and appreciates that an evidentiary hearing about the DA's forensic misconduct and their personal relationships that creates these conflicts is unseemly. Okay, this is like a big problem. Like the judge is like, oh gosh, it is unseemly. And they acknowledge it is an uncomfortable experience for all involved. Counsel does not pursue these claims lightly. Okay. And I agree with this. We're having like some fun with this because it's so fantastical. It's like, what on earth? They indicted each other, went to Napa Valley and cruises, and then she billed for that, and they were banging each other at a judicial. What is going on? But like for the actual people involved in this, like it is uncomfortable. Like I would imagine if you're in the courtroom, if you're the attorneys litigating this, you're like, oh my gosh, we got to talk about you two, in the professional courtroom. Like, okay, we got to talk about you two doing this stuff. Let's go. We got to do it. Let's get to it. So it is uncomfortable, but such is the law. But as noted, DA Willis and Mr. Wade are not the victims here. That's exactly the point. Sorry, it's uncomfortable for you. These are all self-inflicted, completely avoidable errors in which the defense had no hand. And so the defendants cannot be prejudiced by your philandering, but are of such significance the defense had no choice but to put them before the court. And shout out to these defense attorneys for doing it. And in the big picture, because she is the biggest Fani in Georgia, okay? And if she's corrupt in this area, where else is she corrupt? And the big picture here, this discomfort, it pales in comparison to what Mr. Shafer, the defendant, presumptively under our old rules where we used to have the presumption of innocence, remember that? And an actually innocent man has endured. His life has been upended by unwarranted and meritless charges filed by Fani that she does not even have the legal authority or the jurisdiction to pursue. Mr. Shafer, my client, obeyed the law. He followed explicit, detailed, oral, and written legal advice by no less than five learned and reputable attorneys. Could you imagine that? And the only existing American precedent. So he now finds his liberty and his livelihood threatened by powerful levers of law enforcement that have been improperly weaponized against him. Through her extrajudicial and prejudicial statements, DA Willis has further weaponized the media, the public, and now even the church. An evidentiary hearing on the matter set forth in the disqualification motions is critical for the parties, and the court needs to have sufficient information to understand the full nature of Willis and Wade's misconduct and their conflicts to assure that an impartial administration of justice that's promised to every American citizen is afforded to those accused of crimes. And so, based upon all of the foregoing and all of the authorities, we now, David Shafer, through his counsel, respectfully request that Fani be disqualified along with her entire office, and she goes away. Her office disqualified from representing Georgia. Great motion submitted by Craig Gillen. Shout out to Craig Gillen and Holly Pearson, extraordinary defense attorneys, standing in the breach on this very, very complex case and Fani scandal. So that is what they submitted, and we have the hearing on the 15th, so make sure you are subscribed. We cannot wait to unpack that one when it happens. But one issue that we're talking about that might really make a lot of this moot is immunity, presidential immunity. And previously, we talked about the Supreme Court opinions, or the DC Circuit Court of Appeal opinion that came back down, which is likely going to go back up to the Supreme Court. And that DC Circuit opinion we read through here on a prior channel. If Trump has immunity, there is maybe some good argument that the federal supremacy clause, if he has federal immunity, might supplant Fani Willis's case, right? So the Georgia case might go away. So when Trump appeals the immunity decision, we will see what the Supreme Court does on this. But we read through the opinion And we kind of thought it was like a blog post in many ways. It was a lot of copy and pasting, which is what a lot of blogging is. And it was a lot of very short analysis with contorted conclusions. And so it didn't seem that articulate to us. We read through it. We even saw logical inconsistencies, like where they would say and make the argument that Trump was arguing for absolute immunity, but they would frame it in a way that was not what his actual argument was. So it was them arguing around the point. We had many, I thought, valid criticisms of this opinion, but apparently we were wrong. George Conway, the guy who introduced Roberta Kaplan to E. Jean Carroll and set up that whole lawfare situation, the same guy who got divorced by Kellyanne Conway, is a rabid anti-Trumper now. He goes to parties with Molly Jong-Fast and they celebrate Trump prosecutions all the time. And so here is George. I think he is wearing a cheerleader skirt underneath this, right? You can't see below the chyron there, but he must have some pom-poms or something because, man, he is cheering away for this opinion out of the DC circuit.
It was masterful because it combined so many elements. It combined constitutional text, judicial precedent, history, and just sheer logic and the party's own concessions, Trump's own concessions, to make just an absolutely cohesive whole opinion that is just inexorably leads you to the conclusion that he is not immune. And it was just so well done. And it also, one other aspect of the decision, which makes it even more bulletproof, is the fact that they narrowly focused on the exact situation in this case. They weighed the potential costs of not having immunity, which is what Trump talked about, which is the danger of a floodgate of litigation, of criminal litigation, which they poo-pooed. And they matched it up against, as they were required to do by the immunity case law, they matched it up against the public interest. And the public interest wasn't just the public interest in the enforcement generally of the criminal law, but this was the public's interest in constitutional democracy and in the peaceful transition of power. And when you weigh the two up against each other, there's just no question.
Okay, so you see that analysis there? Great analysis. So the public interest is just so heavily weighted in favor of doing what they had to do, which was to deny Trump immunity, that the law didn't even really matter, right? It's just, don't have to really talk about it all that much, because they weighed the immunity considerations about public interest. And they did that in a case that was very narrowly tailored only to this defendant, which is Trump. And then they were so cowardly that they couldn't even sign their names to it because they knew that this was a garbage opinion, as he says. But what, right? That was as fluffy as it gets, enough already. But here's this next question about, well, what should the Supreme Court do about this?
So the real question here is, how does the Supreme Court read this? Because Trump's team says they do plan to appeal it. I mean, you say that it doesn't require further review.
Yeah, it doesn't, because this opinion is so good and so clear, so comprehensive. There's nothing in it that could be possibly attacked. Yeah. And I don't see how even the Supreme Court could write, I don't see how any judge, any court, anywhere, including the Supreme Court, could write a better opinion that more accurately states what the law is and should be. And as a result, I don't think it's worth the court's time to deal with it at this point.
Yeah, forget it. You guys got so much other things to worry about. It's just one of the biggest, most important cases in American history. It's not worth it. It's too perfect.
If Trump is convicted, which I think he will be, they can actually review this after his conviction. And meanwhile, the Supreme Court already has its hands full. On Thursday, it's going to hear the argument in the disqualification case from Colorado, where the court in Colorado held that Trump couldn't be on the ballot because he was an insurrectionist.
Yeah. So, I mean, we don't know what they're going to do, but let's say that the Supreme Court does take it up. Given all of the arguments that Trump's attorney made were totally eviscerated by this court today, is there a new legal argument that they could make to the Supreme Court here?
No, because they threw everything up in the air, and every single argument was methodically and systematically dismantled by this court.
They're not even saying anything. Okay, they're just talking like, people who don't know what they're talking about are talking. Is there anything else he can do? No, he's done. It's done for. Are you sure? Yeah, definitely done. Sure. All right, so that's how they talk, okay? And that's their analysis on CNN. I just want to share that with you. And then this is another person who is also brought out on the media shows. Of course, Crazy Eyes Griswold was on MSNBC's hit show called Inside Jen Psaki. They are big friends. They love having Griswold on. And she came on to talk about her death threats and how scared she is and why one political party is responsible for all of the harm. And I gotta keep emphasizing this point. She is the scoreboard manager. She is the Secretary of State. Okay, these are the people who are counting the ballots, right? Now, she's not explicitly doing that, not literally, but her office is, right? The people who are working under her, the little procedural mechanisms that change up, that might impact red counties more than other counties, they're all, governed by this person. And she is just a carbon copy cutout of the same secretaries that we have in many other locations, like Michigan with Jocelyn Benson, like we have in Maine with Shenna Bellows. And it's just a repeat thing everywhere we go. But how can anybody in Colorado, after listening to this woman, believe that their elections that are run by this woman are free and fair?
Let me ask you about threats. You just raised it. I mean, last month, Donald Trump warned of chaos and bedlam if other states followed Colorado's lead. In terms of threats, I mean, are you concerned about your own personal safety?
Yes, I've been concerned about my safety since 2021 when the threats started to roll in. When this case was filed back in September, within 3 weeks of it being filed, I had 64 death threats. We're seeing the extreme right use threats to intimidate election workers and secretaries of state. And it just shows what is on the line. If a political party is trying to cheat, steal, or intimidate, there are major problems with that party. They are dangerous to American democracy. But just like your prior host said, I won't be intimidated. We cannot be intimidated. In the fact that Donald Trump had the audacity to say there would be bedlam and chaos to the United States Supreme Court, depending on their decision, just reeks of a low-grade threat to me, given his track record.
Okay, so you see those eyes, man, are like extra levels of crazy right there, like right there. Here, oh yeah, right there. Whoa, okay, be careful. Yeah, be careful, whoa. All right, so as you can see, like she is running the scoreboard. She is counting the votes, and she is very, very rabid against anti-Trumpers. And by the way, I don't support any death threats at all. Okay, nothing even remotely close to that. Why? Because it's illegal. You're not allowed to do that. You can't threaten and harass people. It's illegal. So I'm imagining that there are 64 criminal charges or investigations that were looked into about those claims. Were they legitimate threats? Were they just, comments? What is she talking about? I know everyone's under attack all the time now. I got it. And they can use that now as we're under attack, therefore I'm not going to be intimidated, therefore I'm going to go wage war against MAGA. You're the Secretary of State. You run a pretty complicated thing. You're trying to disenfranchise half of your state. People are going to be upset about that. So that doesn't give you carte blanche to go after the opposition and now become a partisan, weaponized person. But of course, that's what she is, and that's what they sound like. So her and Conway probably shop at the same stores and hang out with the same people, but that's what they're willing to do. And so we're going to continue to cover the Fulton County saga. We're going to come back and read Jeffrey Clark, and we'll see what Fani's response is, because she's now trying to quash the warrants, quash the subpoenas for the evidentiary hearing that is coming up next week. We're going to be here, and we're going to be covering that one in depth. So make sure you're subscribed to wherever it is you're watching this, my friends. Thanks for checking out robertgovea.com if you want to read any of the PDFs that we went through. We also have watcherlodge.com, which is now available. And so you can go to watcherlodge.com and grab our latest Survival Squad masterclass that we just did. And it's going to be available there. You can get a PDF, free downloads, and free templates for building your survival squad at watcherlodge.com. Links are down below. So check that out, my friends, and we'll be back here with you on the next one. All right, and so we're not done here yet. We're going to hop on a plane. Will we hop on a plane to go from Georgia to Florida? Maybe. Depends where we're going, I guess, huh? But let's get right to it, because now we've got Florida cases and Jack Smith with Judge Cannon. Donald Trump beats Jack Smith. We have a very serious redaction battle happening and an unsealing battle and an ex parte battle because Jack Smith doesn't want really the public, you or me, to see a lot of what's happening in the court docket. And so a lot of his filings have been directly to Judge Cannon, trying to bypass Trump, or he's filing them under seal, or they're filing them with a bunch of redactions. And Trump's people said, hello, how about we see some of this? We have a presumption of some transparency, of a right to access the record. And so they want this to be shown to all of us. Jack Smith opposes this very regularly. This is the classified documents case. And so we're going to see a Trump victory. And also Jack Smith gets a little bit of some energy from this permission that Judge Cannon is granting. Then Judge Cannon scheduled several hearings that we'll see in the docket coming up soon, and we'll wrap up the segment with a conversation with Representative Luna, who says there was massive collusion in the Trump prosecutions. And so this is the order that came out from Florida in the West Palm Beach Division from Judge Cannon. This is the classified documents case. The order is from the judge, United States of America versus Trump, Walt Nada, Carlos de Oliveira. The judge gives us her ruling. She says, all right, here's the background. Now, this cause, it comes before the court. Let's see if we can translate this history on Trump's motion for permission to file redacted motions to compel. Okay, Trump wants some permission to file some motions. Now, the court has reviewed the motion, has reviewed Jack Smith's response and the proposed redactions, and Trump's reply, and the unredacted versions of the filing, and the full record in the press coalition and everything. The judge says, I've looked at everything. And upon examination of this, and the following says, my independent review of the proposed redactions. Okay, so Jack Smith proposed some redactions, saying against the backdrop of the First Amendment. So Jack wants that silence, but the First Amendment says open that up. She says Trump's motion is granted, in part as indicated below, and the other defendants join that. So First Amendment gets some victory here. Let's see what they say. Background. On January 16th, Trump filed multiple motions to compel the discovery, meaning Jack Smith has a bunch of evidence. Trump says, I'm entitled to that. Jack Smith says, no, you're not. They say, yes, we are. Judge, can you please help? Mom, can you please make him give me back my toy? Eric, give your brother back his toy. Okay, thanks, Mom. Something like that. Defendants, Trump, attached various exhibits in support of their motion, some of which consist of documents, some consist of portions of documents, some were produced by Jack Smith in discovery, and other materials were obtained by Trump and the defense through FOIA requests, through Freedom of Information. So Trump is saying, I know what you have, and I need to get more of this, and I need the court to compel this to happen. Now, Cannon says, consistent with the protective order that was entered previously in June of last year, Trump filed their motions to compel in a partially redacted form. The judge said, before you file stuff in my courtroom, make sure it's covered up so the public can't see it. And then Trump moved for permission to file a substantially unredacted version of their motions with limited exceptions. Okay, and we read through Trump's motion to compel, and there were several big blocks of paragraphs in there that we couldn't read. Remember, like, what is this? What is this? What is this? Trump says, can we please file the actual filing? We want everybody to see that. They say, Trump, these are public. Okay, it's public. And court filings are matters of public record, as indicated by the local rules there in the Southern District of Florida. And they say that Jack Smith has not carried his burden. He says, if we want these records sealed, you have to show a high burden. There is a burden to seal presumptively public records, with the exception of limited redactions only for privacy purposes. And so those are the rules. That's why we want it done this way. But special counsel Jack, he opposed all this. He opposes unsealing the motions because they might A, reveal the identity of government witnesses, or B, reveal the personal identifying information of those potential government witnesses. And it also constitutes Jenks material, which are just like witness notes or materials, police reports, notes, different memoranda, stuff like that. It constitutes Jenks material for potential government witnesses, and so you're not entitled to that until after they testified. So the special counsel also identifies certain additional discrete sensitive information that he argues should be redacted or sealed, and he proposes redactions for the motions and the attached exhibits. So Jack Smith wants this thing locked down. Okay, Trump filed a motion to compel. I want all this material, and there's a lot of good material in there. Jack wants it sealed. So Judge Cannon says, following the parties' submissions and the press coalition, all the media companies, they filed a motion to intervene as well. Okay, so the media is saying, hey, we have right of access to this too. They want to unseal Trump's motions to compel the discovery. They're like, there's a bunch of redactions in there. We want to know what it says. The media says that Trump's motions to compel in unclassified form are presumptively public records. Again, they say, sorry, Jack, you have a heavy burden if you want to restrict this from the public. So Cannon says that the press coalition also requests that the court conduct an independent review of the special counsel's proposed redactions to ensure that the redactions are actually rooted in something that is a compelling government interest that's narrowly tailored. This is the strict scrutiny standard, we call this. And it is supported by the record. Or if not, if the judge is not, in other words, the judge will look and say, look, this is basically compelling. Like, I have to keep this redacted, and I'm going to narrowly tailor the redaction to only match the compelling interest. Now, in the alternative, they want its brief to be accepted as amicus, and the special counsel obviously opposes the press, right? So Jack Smith is not in agreement with the media over this. So they give us some legal standards here, telling us by way of background that the press and the public enjoy a qualified First Amendment right of access to criminal trial proceedings. Now, although the contours of that right remains a developing area of law, like, for example, we don't get videos, right? Where are videos? A right of access to criminal trial. We don't get videos in federal court. What kind of access? I don't have any access to it. I can't call in to any, court proceeding. There's no, unless I show up to court, right? So the access is pretty limited, like physical limitations. And even then, they're like, no, you sit in the media room and you get to look at the monitor. But okay. Although the contours of that right as applied remains a developing area of law, several courts, with limited exceptions not relevant here, have applied, this is Cannon speaking, the First Amendment right to judicial documents and records, including documents filed on the court docket, citing some case law. Now, in this case, neither party argues that the First Amendment does not apply to Trump's motion to compel or the materials here. So the First Amendment does apply. Now, in light of these First Amendment principles, Cannon says a party like Jack, who is seeking to seal or redact the court filings, they carry a heavy burden, and the party requesting closure must demonstrate that such action, in this case Jack, is necessitated by a compelling government interest, and it's narrowly tailored to serve that interest. It can't be overbroad. Some more case law there. Saying further, in ordering that the documents, in fact, do be sealed from public view, the district court must set forth a specific legal and factual basis for that order, why it is restricted. Cannon says this strong presumption of openness is reflected in our local rules. That's what they say. It says proceedings are matters of public record. Any party seeking to seal the record must, their rules say, set forth a factual and legal basis as to why it should be sealed. The court has emphasized these principles throughout this entire case. Those are the rules. Now, here is her discussion section. Following an independent review, my analysis is, of the motion and the full record, Judge Cannon determines that with limited exceptions as detailed below, that the special counsel, Jack Smith, has not set forth a sufficient factual or legal basis that warrants a deviation from the strong presumption in favor of public access to the records at issue. Victory. Sorry, Jack. You lose. You don't get to keep this stuff under lock and key. Most of the special counsel's proposed redactions concern sealing the identity of potential government witnesses. Now, in support of that request, Jack refers in general terms to witness safety and intimidation. Remember this? Why do you need it sealed, Jack? Why can't we just see what you're doing? Why is everything done under the dark of night? He says witness safety and intimidation. and Jenks Act. Now, although substantiated witness safety and intimidation concerns, they can, says the judge, form a valid basis of overriding the strong presumption in favor of public access. Jack Smith's sparse and undifferentiated response, it fails to provide the court with what we actually need in terms of a factual basis to justify the sealing. You can't just make witness intimidation. How's that sound? Okay. No, not good enough. We need more than that. Nor is such a factual basis provided in their sealed filing that we haven't read here. Now, Cannon also, she's holding Jack Smith to a standard, says, look, Jack Smith also alludes again, in general terms, just whatever, to the concern, he says that, quote, public disclosure of witness identities or their statements in advance of trial also risks infecting the testimony of other witnesses or unnecessarily influencing the jury pool. And she says, okay, well, all right. Even accepting those rationales for sealing the case, Jack's submissions offer nothing in the form of any concrete factual support for these rationales. Do you have any actual evidence, or are these just generalities, platitudes? For those rationales, or otherwise identifies any supporting evidence in the record to justify that broad and unspecified request on those bases. This is not Judge Chutkin's courtroom. I need some evidence. So this leaves 4 categories for resolution in the seal request. Personally identifying information about government witnesses like dates of birth, email addresses, telephone numbers, references to signal intelligence subcompartments, references to FBI code names of a separate investigation, and uncharged conduct as to one or more individuals. Like, well, we might charge some other people. Now, the court takes these issues in turn, following a careful review of all of the documents and all of the exhibits that Jack Smith sent in. First, as to the personally identifying information, the court actually agrees with Jack Smith and Trump that the sealing of this information is no problem. Yeah, nobody cares about that. Permitting the redaction of birth dates, okay? Social security numbers, that's fine. Home addresses, got that. No one's complaining. So Trump is therefore directed to comb through the materials carefully, redact the email addresses, okay. Redact the phone numbers, no problem. Dates of birth, social security, and any home addresses, got it, easy. So no problem. Now, second, the court, here's what they say. Now, in redacting, she gives some instructions on the emails. In redacting the email addresses of special counsel witnesses, follow the convention employed by Jack Smith. For example, if the document contains the following reference, John Smith, like John Smith 1 at sample.com, the document should read as follows: John Smith, first part of the email is redacted at sample.com. So don't put his email here so that, people can email. Now, second, the court determines at this stage that the special counsel's national security concerns are sufficient and they are specific to warrant the sealing of the signals intelligence subcompartments, saying this is protecting the secrecy of information that's important to national security. So that gets sealed. And third, with respect to the desire to shield the FBI code name of a separate investigation, they say neither the special counsel's publicly filed response nor the sealed filing identifies the information it seeks to redact. Now, although protecting a portion of their law enforcement investigation can constitute a compelling government interest, Jack Smith fails to identify the information at issue. He doesn't provide any explanation about the nature of the investigation. He doesn't explain how disclosure of the code name would prejudice or jeopardize anybody. So his request on this point is denied. Sorry, Jack, you don't just get to ask for it. You got to tell us, why is the FBI code name, if we don't know what it is, why is it so problematic? And fourth, turning to the exhibit discussing uncharged conduct for other individuals, they say, Trump does not present any opposition to the public filing of that information. He doesn't care. And special counsel has failed to articulate any other legal basis for that redaction request. And so an insufficient basis has been provided to seal that. So therefore, it is hereby ordered and adjudged by Judge Cannon in Florida that Trump's motion is granted in part. File it unsealed. Just cover up the personal stuff. Press Coalition's motion is moot. We're unsealing a bunch of stuff, so you're happy. On or before Feb 9, Trump shall file under seal a proposed public version that is consistent with this order under seal. So send it to me first. I'll make sure it's good. If I find that you did a good job and you didn't over redact, then I'm going to direct the clerk to unseal the filing. Good. We'll get to read that one again. The parties are reminded of the strong presumption of public access in criminal proceedings. The motion for leave shall be filed publicly. Says there shall be no filing under seal of any unclassified material. Do not file anything that's unclassified under seal unless you get permission from us. The motion for leave shall be filed publicly except in clear and supported cases of risk to personal safety or national security. Jack Smith is not happy. The party seeking authorization to seal the material shall not file or otherwise attach the material, so don't accidentally publish this stuff. And I'll let you know. Send it to me first, and then I'll unseal it. She's being very careful about this, but she's also unsealing it, which is the right call, obviously. Jack Smith, if this case is so legitimate and above board, he should want us to see it all. No, we got him dead to rights. Trump did this, Trump did that, Trump did this. But no, they got to keep it all under seal because they're concocting their case right now. Now, here is what Chutkan said. So Jack Smith did file something. And this case now, special counsel, he filed a sealed motion for permission to file sealed and redacted documents. It seeks permission to file a redacted version of his response to their motion. So he's following the sequence. He incorporates the position, and so granted in part, file your stuff, comply with the redactions, on or before this, file under seal a proposed public version. So file it under seal, give me your proposal for a public version, and then we'll unseal this motion, right? So all of this by Judge Cannon. So it's going to be a lot of this process. That's why these things take so long, and this case is taking so long. Cannon also scheduled a sequence of hearings. Says on February 12th and 13th, the court in Florida, a bunch of stuff is coming up, but these are going to be sealed ex parte hearings. So one side to talk about the Classified Information Procedures Act. So this stuff is happening under seal, and it's with only one side. Now, these proceedings are going to be held in a facility suitable to discuss classified documents. Monday, the 12th, 9:30 to 2 p.m., the court is going to hear argument from Trump's team outside the presence of Jack Smith. Just Trump, just the judge. Consistent with these orders, Walt Nauta and De Oliveira may not be present. Trump's lawyers shall be prepared to discuss their defense theories of the case in detail and how any classified information might be relevant or helpful to the defense. Counsel should also be prepared to discuss Trump's motion for access to the SEPA filings and other things. Then from 3 to 5, so Trump gets a lot of time, 9:30 to 2 p.m., then from 3 to 5, then Jack Smith comes in the room, and they're going to be prepared to discuss this as well. Then they come back on Tuesday. It can be a full day on that day. Then on Tuesday, they come back. Further proceedings as necessary, and additional stuff will be filed, signed by Judge Cannon out of Florida. So more activity on this. A lot of it's under sealed. I really wish we could see more of it, but we are going to see some more of it because Cannon is siding with Trump, siding with the First Amendment, siding with the right to access, which is the right way to go. Not gagging Trump. Like, think about these jurisdictions. One is gagging Trump and silencing him and putting everything under that she can under seal, right? Handling all of that. Whereas here, this judge is allowing us to talk about this stuff, right? Putting it on the docket, saying unseal it and let us see what's inside. So we're going to be here continuing to cover this. Obviously, we'll see what happens after those hearings. Representative Luna was talking about the various Trump prosecutions and saying, no matter how much they lie, smear, and attack Trump, he is going to win. This is all just lawfare, and the American people are going to see through it. Here is Luna.
We have the ability and at our disposal tools to find terrorists in caves in the Middle East, yet you can't find someone who planted a pipe bomb. That's pretty egregious, but we have evidence that the government really helped to cover up what was happening, and I will just point all of you to what happened at Oversight, where we actually questioned Twitter 1.0. We saw that under the Department of Homeland Security, CISA was actually working to not only suppress information, to include the president's statement to remain peaceful on January 6th. Remember how he said that? Yet it was nowhere on social media. It's because these outlets, whether it was Google, Twitter, Facebook, Instagram, they're all working to suppress that information. But I wonder why. I wonder why they would want to do that. And it's because this president is truly a man that is outside of the DC control. And frankly, that's why every single person, I'm pretty sure up here, has endorsed him for re-election, and he's going to win in November. But I want to ask you all questions on whether or not you think that we should be charging someone like Hillary Clinton with insurrection, someone like Stacey Abrams with insurrection, because they all claim that they won elections. We know that Hillary Clinton was full of it. We know that because we saw what come out. In fact, you guys know that I all censored Adam Schiff over it. There was no evidence of Russia collusion. So I want to close with saying this. What we've seen happen over the last couple of years has not only been depressing as a member of Congress to witness how much people up here have actually used that lie, used that narrative, not just to smear President Trump, but to tear apart this country. But I do applaud what Representative Gates has done. And what I will say is that those sociopaths that continue to push this lie, once we have this on the floor, if you continue to push this, you guys are all going to be guilty of breaching House privileges, okay? Because we're saying that it didn't happen. We have evidence to back it up. So just think on that for a little bit.
Ooh, Luna, think on that, punks. You're right. Hope they do think about it. And I think she is right that Trump will be victorious in the days, months, and weeks ahead. So, my friends, that is what's happening in Florida. We're watching the SEAL redaction battle unfold. We're seeing more of it is going to become public now, and we're happy about that. So we'll be covering it when this stuff gets unsealed. We'll see what's inside, the good stuff. We are going to bring right back here. We hope you join us as we do. Don't forget to subscribe wherever it is you're watching this. I'd really appreciate you hitting that like button if you see it available and handy. We've also got a bunch of great links in the description below. Watcherlodge.com. We have our newest workshop, which is now available and live. It's called the Build Your Survival Squad workshop. It's free. It's available over there. So go check out the template. Go check out the slides and the full workshop that we did at Watcher Lodge. Website, robertgovea.com, has all of these PDFs inside. So if you want to take a closer look, go through the red lines, check that out. And we'll look forward to seeing you right back here on the next one. All right, my friends, that is it for us on the day. And we are going to leave it there. We covered Jack Smith and Trump, the battle over the redactions. We talked about the egregious Fani, who is now trying to fanny her way out of a hearing. And of course, now it's time to hear from you. We are going to go over to watchingthewatchers.locals.com as soon as we say hello to you for our members only after party. We do Saturday streams there. We do morning streams there. We already did a full stream this morning. Come check it out, watchingthewatchers.locals.com. All right. And let's see who is in the house, my friends. Thank you very much for your amazing generosity today. We've got some good comments from from Glocky. Glocky, hey, did you hear this news? Nikki Haley lost last night in Nevada to her number one opponent, which was called None of the Above. She lost to None of the Above. She got outvoted. Did you guys see that? She says, "Stop giving me your toughest battles, Jesus." He says your only opponent was none of the above. I don't know what else to tell you. I can't help you there. All right. Even Jesus can't save you, Nikki Haley. All right. So funny. Funny. You're giving me so much to deal with in my life. There was literally no one else on the ballot, Nikki. What else do you want? All right. Funny. What's up, Rob? Says, I did not have relations with that woman, Judge. Miss Fat Fanny. It all depends on what the meaning of Nathan's hot dog is. Your Honor, it depends on what the definition of Fanny is, doesn't it? All right. A bad poet says, Fanny, the democratically elected public servant. That is to say, she ran unopposed. I would add that to RICO and look into collusion with law enforcement. Or is that a stereotype of town officials? Well, she did run unopposed, didn't she? That was pretty curious. Yeah, she won. We just read that. Well, apparently that's what the people of Fulton County are into. They're into Nathan's hot dogs, I guess. And Fanny really has full authority to do that. What's up? We got, that one's not low. Here it is. Hey, what's up, Jigam? Jigum's in the house. Says, busy day for you, Rob. Morning show, disaster planning show in the Watchers Lodge, and an evening show. Hope you were able to sleep in between all that. Thanks for all you do. Today was definitely a busy day. Okay, today was definitely busy. And yeah, it was a little bit busy. But it's great. It was a great day. And what we're planning is just going to continue to even get greater. So the disaster planning show was at Watcher Lodge. It was a lot of fun. And make sure you check that out. Go check it out because I'm going to yank it in 48 hours. Jigum, thank you for the very nice dono. We're having a lot of fun. I hope you're enjoying it. We're trying to, produce some more content and have some fun. So hopefully you're enjoying it and having fun with us. We got RF says, hey, what's up? First super on a live stream, RF. Thanks for being a membo and for trying out the super chat functionality on our stream. Very grateful to be your first. Chubby's here. Says, if it weren't for double standards, a majority of the left wouldn't have any standards at all. Old cliche, but still holds true, unfortunately. That is a good cliche. Man, if it wasn't for double standards, I'd have no standards at all. Yeah, it's kind of a funny one. Good to see you, Chubby. Thanks for that. Hey, this one from Glocky says, I was going to be a prosecutor, but my mama said be a bank robber. People actually like bank robbers, and they have more integrity than prosecutors. But your mom sounds awesome. Shout out to your mama. She knows how it works. We got Private says, Larry says, in private business, if you get caught taking kickbacks, you get fired. Yeah, or prosecuted, yeah, in some situations. Now, in Fulton County, kickbacks are business as usual. The uninformed voters got what they deserved, which is corruption. Good to see you, Larry. And I don't know, is Fani, like, what are her approval, numbers? I don't know. Maybe they're like, yeah, go girl. Get that hot dog. Sandy says, if Fani's entire office is disqualified, does another county take place? Does the case physically move to that county, giving way for a new jury pool? No, I think what they would do is just sub in another county's prosecutor. They'd keep it here. It's a Fulton County crime. It's a Fulton County case. It involves Fulton County officials, presumably. So I think they'd keep it there. Keep the same jury panel. The court would keep the jurisdiction. They would just sub in a new prosecutor. So like McAfee's not going anywhere, right? He's going to keep it there. It's all going to stay on track other than that. This one came in from Glocky. Here, let's see what this one says. Yeah, okay. So here's one from Elmo. All right. This one's from Elmo. And we're going to call that powdered donut frosting. That's Hunter Biden's powdered donut frosting. This says actually prosecuting a case based on evidence, which is fruit and vegetables, slapping Fani's big booty and embezzling tax dollars. You know where Elmo's going or where Nathan Wade's going. That's from Glocky in the house. This one from Suzanne. What's up? Hey, Suzanne is our newest supporter in the house. Welcome aboard, Suzanne. It is great to see you. Very nice to have you. Here's one. Ballpark regular length hot dogs, which are very expensive on their own. I mean, you go to a ballpark, what's a hot dog, like $12 now? I mean, I don't know what it is. I don't even know. Ballpark regular length hot dogs, $12. No thanks. Nathan's foot long with a side of tax money that costs Fulton County $1 million. That's what we're talking about. That's what we want. That's how things are going there in Fulton. Jay Ben says, what was the point of getting a special prosecutor in the first place? Great question. Why did she hire him, right? She's got a ton of attorneys. Why didn't Fani's office handle the investigation and the prosecution? Has Fani stated this anywhere? It's come up before. It has come up before. Actually, I think it was in Mike Roman's original filing. They were asking, like, all these other dudes are qualified in your office. You could just move them out or whatever. Just wondering if she did this to try to show impartiality, if there was some other purpose. No, I mean, I don't think anybody really questioned it. She just said, well, it's a political case and I want to make sure my office is not involved. And maybe there's some conflicts. No, not even that. Yeah, I mean, people are asking that. They're asking, why did she hire him? There's no reason to do that. She's got a big office, lots of prosecutors, no reason to do it. Because they were in love, right? That's the point. Hey, this one. This is from Glocky. Another meme says, charging Trump for RICO. Very excited. Trump attorneys present evidence that you should be prosecuted for RICO too. have a little bit of a change of opinion there. Dolphin Fan is the man bringing in new membos. Chris C's coming in. Summer La Liberté is coming in. Save America Trump is coming in. And the Shark is coming in, courtesy of Dolphin Fan is the man in the house. Great to see you. We got this one from John Allen. Says, good afternoon, Robin Watchers. What's up, John? Says, Hunter's crack dealer here in the house. Says, I'm just curious if you reserve that crack dealer position in that survival squad you've put together for Hunter's crack dealer. Would he be useful in our squad? Just letting you know that I have stocked up on all the good stuff for our special squad members. I'll be making sure that we will definitely have some great parties. Got to keep everyone happy, you know. It's the least I can do for all of your promotion of product once Hunter has disappeared once again. So Hunter's crack dealer, man, we're going to have a very, very active, highly energized survival squad because we'll be on whatever Joe Biden's taking and maybe that cocaine in the White House. All right. So thank you, John. And Hunter's crack dealer, thanks for being here and keeping us plastered with the good stuff. Rob says, how much of this money is from federal grant money? It's a good question, Rob. And Jim Jordan is looking into that as we speak. We'll see. Mark, but that was COVID money too. That was supposed to be used for clearing out criminal backlogs, which it was not. Mark Butcher's in the house. What's up, Mark? Thumbs up. Thanks for being a membo, my friend. Thank you for that, Mark. Appreciate you being here and for being a membo. Thanks for sending that one in. Knox is in the house. A defense attorney in Texas says, happy Wednesday, all. George Conway is one unattractive man. Blech. Poor Kellyanne. Well, she's free. She made a smart call, got out of that sinking ship. And she's free. Hopefully she's having a good life, free from that. Glocky says, we aren't a damn constitutional democracy. We are a representative constitutional republic. Always a good reminder. Rachel says, it's not just the eyes. Her whole demeanor is devoid of human emotion. That's right, Rachel, isn't it? Every time I watch Crazy Eyes Griswold, I try to understand what else is there. Like the eyes for sure, the eyes are the window to the soul, as they say. But Jenna, it might also be that her head doesn't move. There's something a little, what is the word? Unsettling when she speaks. It's unsettling. It's like uncanny valley. Like this is just weird. I can't put my finger on it, but there's something just a little bit strange about how she handles herself. It's strange. I agree with you completely. John Allen says, also, Rob, last Friday I sent a dono wishing you and everyone a great weekend and complimenting you for such a great stream as always. But Locals glitched and didn't post the message while deducting the coins. Ugh! Locals tech support is obviously getting their crack from other unreputable suppliers, explaining all the Locals issues lately. Anyways, I'm not worried about the money other than I hope you definitely receive it. It wouldn't bother me if they were my client since I could only blame myself. Says, P.S. Jake from Oxford owes me for his bender, which explains his last message about being on the squad. Come on, Jake. Pay your tab, buddy. And so we have Jake Sullivan, the national security advisor, who comes into our Locals community and educates us on how stupid we are and how smart he is. And so that's what we're talking about here. But John, I'm sorry that your prior comment didn't come in. Sorry I didn't get to read it. I did not see it. I try to read everything, but sometimes I just miss it. It's either my fault or the technology, something's just going off. So John, I apologize that we missed it, but I appreciate you wishing everybody a very nice Friday and a nice week. And I appreciate your support here, however we get it. And sorry the tech glitched out, but thank you, John and Hunter's Crack Dealer, for being a mod and supporting our community, keeping the fort nice and orderly. We got Fred says, your life literally depends on the judge that you get. Yeah, a lot of that's true, Fred. A lot of that's true, unfortunately. Shout out to Johnny, your rascally dog. NY says, enjoying Fani news while upgrading my fluorescent lights in my garage. Well, that's a fun project. Are you up on a ladder? Be careful up on the ladder. Fluorescent lights. Yeah, they're kind of fluorescent lights. Yeah. We got Mini Wheat says, Rob, sorry if you, I had a lot of thoughts about them and it's not worth getting into. Rob, sorry if you talked about this already in another stream, but do you know anything about Judge Engeron going after Alan Weisselberg for perjury? A little bit. We haven't talked about this yet. It's in my queue. Weisselberg submitted a letter to the attorneys saying, can you please clarify what's going on? It was about a paragraph or about a page email. And I was going to do a segment on it, But at this point, he's only, it sounds like, inquiring, right? He's asking the other parties what their positions are on Weisselberg and perjury, saying, did he lie in my courtroom? What's your position on this? Is there another explanation? Is there another interpretation? So I think it's just kind of in the inquiry phase. But that's about it. If there's more reactions or more response or Trump's people respond or whatever, then we may do a full segment on it. But right now, I think it's kind of still preliminary. Red One says, will Tucker's interview have an impact on the election? Great question. I would say yes. I would say probably. I think it will be the first time that many people have heard from Putin in this way since the war started. I mean, honestly, has he talked? Have we heard from him at all? I think a lot of people might say, yeah, because they're juxtaposing that with all of the other questions that we have right now. Why did our border bill, which had $20 billion for the border, have $60 billion for Ukraine? Why do we spend hundreds of billions of dollars on them? Why is $60 billion more than the entire budget for the U.S. Marine Corps on a given year? Why is that? Why do they get a bigger Marine Corps than we get? So then Tucker comes out and says, yeah, actually the Biden, or Putin says the Biden people wanted to deviate a settlement early on this thing where obviously, whatever he says, people are going to ask themselves, oh, maybe that makes sense more than Biden's story makes sense about Ukraine. They still haven't really given us a good explanation as far as I'm concerned, other than the analysis is Putin's going to march across Europe. That's he's going to take over Europe and your American kids are going to be fighting and dying over there. That's not the answer that I'm interested in. Okay, that might have worked 20, 40 years ago. It doesn't work anymore. What are the national interests? And Tucker's going to ask questions about that. And we have a right to know. And Tucker is inspirational for going over there and doing that. We talked about that this morning on our members only stream. It's like, my goodness. Think about what they're doing to Elon Musk. Think about what they're doing to Trump. Tucker jumped into that ring willingly. He said, okay, let's go. And Ukraine's huge, man. Ukraine might be even bigger than X, than losing control of the social media companies. If they lose control of the Ukraine narrative, think about how mad they're going to be about that. And Tucker just said, yeah, let's go talk about it. Sure. When they're taking Elon's $50 billion, right? The apparatus is orienting to stop the threats to the apparatus. And Elon's one of them. And he got, he's under scrutiny every day from every entity in the federal government that they can muster up. Trump is even beyond that, criminal charges. So Tucker just says, sure, I'll play that game. Holy moly, man. Really, really inspirational. Carmen, what's up, Carmen? Carmen B, our newest supporter. Good to see you, Carmen. And YouTube members, you can grab the Telegram link to join us for our members only after party. You just got to go to the YouTube channel, navigate to the community tab section, scroll all the way down a few months back, grab the private Telegram link. We'll see you there. NY says, the Georgia AG refused to charge. The Georgia AG remained silent and he could have prevented her from filing the charges. She is a county prosecutor. Election crimes are state crimes. From NY Renal in the house. We got Michelle. What's up, Michelle? Michelle got a gift from Dolphin Fan. Is the man in the house? Thank you, Dolphin. We've got Neurodivergent says, on one hand, I hope Fani gets booted from the case. On the other hand, the comic relief she brings us is priceless. And that is true too. Yeah. If she gets booted, the case might be dead. It might not, right? They might sub in another prosecutor. If she doesn't get booted, then this whole case, I think, really becomes about her. She's going to overshadow the case, and that's going to be good for all of the rest of the Trump prosecutions. She'll become symbolic of the corruption. And they got to be so mad about that. Hey, Sergeant Willie says, the Nathan's company is getting a bad rap. Are they? I don't know. A lot more people are talking about Nathan's hot dogs than I've ever heard about before. This old guy says Jenna is a Botox overdose. Well, she's got some other, concerning features, like the fact that she wanted Harrison Floyd to go to jail. That's my most concerning concern with Jenna. But also that you're right, this old guy too. Pinochet says, shame when the internet autism outs the Air Force E9 who planted the training pipe bombs. How do we know J6 was a fed op? because only they could screw it up. Yeah, if anybody else wanted to do it to be successful. Here, Sandy says, the New York Attorney General sent a letter about Weisselberg. Might be a good topic for tomorrow. Reads like panic to anger on. Get your ruling out. Don't wait about Weisselberg. Interesting. Okay. Thank you, Sandy. I've not seen that one. Yeah, thank you for that. I only saw the original letter that he sent out. Here it is. Ooh, it's a 9-pager. Ooh, yeah, maybe we can talk about that tomorrow. Oh, that actually might be good for an anger on update tomorrow. Thank you for that, Sandy. Very convenient. I appreciate that. We've got another one. That was it. That was our last one from Sandy in the house. And so, Sandy, thank you for sending that in. Let's say hello to our friends on the X platform before we go over to watchingthewatchers.locals.com for our members only after party. And who is joining us on X? Let's see who's here. Anybody watching us on X? Is there anybody here? 18 people. Oh my goodness. We got 18 viewers on X. And hey, here's our friend Paul Mino. He says, got girth? Get your red pens out, man. Meme Smith Mino is in the house. Says, get your red pen out. Says the red marker skills are on point as usual. We work hard on those, Paul. It's important to mark it up so we don't miss anything, you know. V says, so all I have to do to expatriate is to interview someone like Putin. I don't have to pay thousands of dollars to the U.S. government anymore. Good to know. V, are you going to Moscow? Darkside says, great show as always, Rob. Question, if the entire RICO case gets tossed by McAfee, what happens to the people that took the diversion deals? Do those still stand or no? That's a good question. I would say that those still, I mean, you know, they may make arguments for post-conviction relief and other things, unless the judge, you know, I would say that those would stand because they pled guilty and those cases are closed. Now, they're all diversion deals, so they're ultimately going to be dismissed anyways, right? But there is a mechanism under the law. It's called post-conviction relief. So like after you've already taken a guilty plea or diversion deal, if you discover something that you didn't know after the fact that might change the course, you might be able to file a petition for post-conviction relief. But it's a complex area of the law. It's kind of like the opposite of it. It's kind of like an appeal, but like there are people who specialize specifically in PCRs, post-conviction relief, because it's a whole area of the law. And that would be, I think, the mechanism that they would use to get out of their diversion deals. But I think those are done, right? The orders are in place. They're probably already doing diversion, already checking in with someone. So it's kind of already done. Obscape says, isn't this interesting? If the trips were overnighter, did Fani and Wade cook hot dogs together at Trump's DC hotel? Wow, that's an email. That's an X from Jason Smith, although that one is not available anymore. I wonder if he deleted that. Goofy for Jesus is here. Lil Nuggets here. Goofy says, Haley and her campaign flaunted that they didn't spend any time or visit Nevada. I wonder how that's going to play out in the future. Lil Nugget says, the biggest Fani is also the biggest narcissist gaslighter ever. Mind-blowing. Rob, so happy to see you made the cover of Time. Well deserved. I made the cover of Time. Is that from Paul Mino? Is this the cover of Time? Got girth? It's important to have girth too. We have to outgirth the left, always. V is never silent, says, with all the voter fraud information coming out, how is this trial still relevant? Well, their eggs are in the basket. Supra says, today I decided to send something because I have a question. Wade said that he did the job for free for sheriff, and he made $5.50 an hour at the other inquiry. Yeah, the other one where he didn't take any notes. Remember that? Angela says, glad we have some real information coming out, slow but steadily. The truth will set you free. And so, my friends, that's what we've got over on X. We post our videos to X. Thank you for retweeting those and liking those. And of course, thank you for liking and following other watchers out in the wild on the X platform. It's good to support each other and help each other out when you're browsing the interwebs. Now, that is it for us on the day. We are going over to watchingthewatchers.locals.com for our members only after party. We have a couple new donos that came in. What's up? Riley Leifson says, hey, Bobby, G-Unit. Just wanted to throw a few bones to the comms guy. Also, that's me. I'm going to be the comms guy for our survival squad. I'm really interested in getting my ham radio license. And maybe we might even do a ham radio study session at the lodge. So if you want to get your ham radio license so that your license and you have a call sign like TQ5, 275, whatever, you can get your ham radio license. That's part of the comms division, the comms role at watcherlodge.com. So check that out. And we also talked about 50 Cent this morning, who is now known as $2.50 because of Biden's inflation. So he says, just wanted to throw a few bones to the comms guy. Also, the way the media portrays the brilliant Miss Abba, it infuriates me. Well, they're just upset that they're so ugly and that she's so good looking. They hate that, man, especially when you're smart too. They hate that. They're like, oh gosh. Because look at them. I mean, look at Roberta Kaplan. Look at E. Jean Carroll. Like, just look at them. Pinochet says, I bet, hey, K77 TEC in the house. I don't have one. I'm going to get one. I'm going to get my, hey, we got another one over here. I'm going to get my call sign, man, and we're going to ham it up together. We're going to live stream and ham it up. I can't wait. Pinochet says, I bet the feds in the chat are even angrier. We have the cell records of the pipe bomb planter. That guy made interesting calls. Oh, and we got his plates too. We got, hopefully they know who he is. I thought they said that their Wi-Fi, their cell towers were down. The data was corrupted. Remember that? The data was corrupted. We couldn't find the data. Hey, we got KO4 SVIs in the house. What's up? Yeah, so the ham radio test is apparently not that complicated, okay? You just have to, the answers are all available. Just study the answers, the questions. But I want to learn about it. It's going to be fun. Hey, Mark on Facebook says, I have my ham license out of Illinois. It's not that hard to get. Yeah, I don't think it's that hard. KO4 SVI WA4 OSH is in the house. We got all these call signs. We got all these call signs in the house. How cool is that? All right, we're going to be hamming it up, my friends. I'm going to get my license so that I can get my own call sign. Hopefully I get something cool. We'll see. All right, so my friends, we are going to wrap it up. Go over to watchingthewatchers.locals.com. And that's where we're going to be hanging for our after party. We do member streams. We do Saturday shows. We'd love to see you there. But if not, that's all right. We are going to be back here tomorrow to get into it all again. Oh, tomorrow's Thursday. We're going to stream. I think the plan is, unless anything changes, unless you guys tell me no, I think we're going to stream the oral arguments of the Supreme Court. Do we want to do that? Do we want to stream the oral arguments? It's early. So we'll do a morning stream. I think we'll just do it publicly. We'll cover the SCOTUS hearings. It starts at 8 a.m. my time, 10 a.m. Eastern time is SCOTUS arguments. I figured we'll all probably be watching it anyways. Like, we'll all be listening to it anyways. So we might as well just stream it here. Definitely. Yes, says Golden. All right. Tanya says yes. Okay. Yeah, sure, says Zach. Good. Carrie says, okay, we'll do that. It shouldn't actually be that long. I mean, oral arguments are like 90 minutes. I think there's 2 cases that are scheduled, so we'll see. Are there 2? I'm not sure. I'll check. But all right, we'll plan on it. The consensus is there. We'll do it. We'll do a public stream. We'll just hit the SCOTUS briefs, and it'll be a little bit earlier than usual. Then we'll do a show. We'll see if there's other filings, and maybe we might do it again in the show. Like we might hit some clips in the show. I don't know. We'll see. But that's the plan. All right. So oral arguments for Trump's immunity. Okay, Trump's immunity is Trump's ballot removal for Colorado. That's taking place tomorrow. So tomorrow morning, 8 a.m. Mountain, 10 a.m. Eastern time. We're going to be back here, probably go live a little bit early so we can get our bearings straight. And then we're going to talk about the SCOTUS ballot removal, Colorado litigation. It's being argued in the Supreme Court tomorrow morning. So we'll be back here for that. So 9 p.m. Central, and we'll get into it. All right. That's the plan. That's the plan, my friends. So we're going to leave it there. We're going over to watchingthewatchers.locals.com to get into it again. We will be back here in the morning to get into SCOTUS business. And so, my friends, I hope to see you right back here in the morning so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. We got SCOTUS in the morning. I'll see you right back here tomorrow. Bye-bye.